When a business develops information that is unknown to its competitors, it may be capable of being protected by either a patent or a trade secret. So what one is better? Well, in today's presentation, we'll be comparing patents and trade secrets by looking at a number of different criteria. But firstly, what is a trade secret? According to Article 39 of the TRIPS Agreement, a trade secret, or confidential information as it is known in Australia, is information which meets three factors. Is secret in that it is not generally known to the public, has commercial value, and is subject to reasonable steps to keep it secret. A trade secret is clearly superior to a patent in terms of the duration of protection. The monopoly enjoyed by the holder of a trade secret is not limited in time and may in fact continue indefinitely, provided that the secret remains confidential. A patent, on the other hand, provides the holder with a limited monopoly of 20 years. Take Coca-Cola for example. If the company decided to patent the secret formula when it was invented in 1886, it could now be freely copied by anyone. However, the formula has remained a secret for over 100 years, allowing Coca-Cola to remain as the industry leader in soft drink.
And as you can see, the unique dents in my invention perfectly match the contours of the human vertebrates. Patent pending, patent pending, patent pending.
In order to gain patent protection, the relevant government body, being IP Australia, must be satisfied that the invention is in accordance with Section 18 of the Patent Act, namely that it is a manner of manufacture, novel, inventive, useful, and was not secretly used. Additionally, those seeking a patent are required to freely share their knowledge with the world. This includes explaining in sufficient detail how others can create and use the invention after the patent has expired. Consequently, rivals may gain enough information to effectively invent around the patent, making it redundant. Applying for patent protection is a timely process and can take between 12 to 18 months. Should the patent be denied, the invention would be unable to be protected as a trade secret. Trade secrets, on the other hand, are not subject to any application process, nor are the holders required to make any disclosures. As trade secrets are not registered, they may be defendable in court immediately. Both patents and trade secrets can be bought and sold, though patents enjoy an advantage over trade secrets given all the relevant information is publicly available, making it easier to value. The holder of a trade secret has to be careful not to destroy their protection by revealing the secret. However, it is unlikely that a buyer is going to enter into an agreement without first being able to assess the trade secret's worth. In order to sidestep this complication, the parties may enter into non-disclosure agreements, which adds time and cost to the negotiation process. Trade secrets are only protected against improper acts such as fraud, corporate espionage, and breach of contract. Honest and fair acts such as reverse engineering or independent invention may lawfully defeat the trade secret. So there is nothing stopping anyone from working backwards to figure out the recipe of Coca-Cola and then selling it themselves. As a result, Coca-Cola is required to take extraordinary measures to protect the secret, such as ensuring that no single supplier has the full recipe and that access to the recipe is restricted to only a handful of executives. Indeed, it is rumoured that they are not allowed to travel together. Patents, however, provide more secure protection. Holders are granted exclusive rights, with third parties prevented from making or using the invention, regardless of whether the use is intentional or not. Hence, independent invention is not a defence. It is also argued that defending patent rights from infringement is less complex and less costly compared to a trade secret. It is estimated that the cost of obtaining a standard patent in Australia lies roughly between $5,000 to $8,000, which includes attorney fees. The patent holder is required to pay annual maintenance fees, which adds an additional $8,000 to the overall cost. Whilst trade secrets are free to obtain, they incur large costs in order to maintain confidentiality. Some of those expenditures may be modest, such as non-disclosure agreements for employees and suppliers, or they may be extravagant, such as constructing a secure facility and cybersecurity program, which could prove to be overall more costly than a patent. The Coca-Cola formula, for example, is stored in a high security vault. As we have seen, both patents and trade secrets have their advantages and disadvantages. The decision on which is better ultimately depends on the nature of the information and the industry. Thank you for listening.